This copyrighted video was produced by the California Department of Rehabilitation and is intended solely for educational purposes.
In talking about hiring and maintaining awesome employees who happen to have a disability, we really ought to start with, what does the law say about this subject? That's why we are happy to have Phyllis Chang here for Ask the Expert. Hi, Phyllis. Welcome to the show.
Thanks for having me on.
Why don't you tell us a little bit about yourself?
I'm the director of the California Department of Fair Employment and Housing, the state civil rights agency charged with the investigation, conciliation, mediation, and prosecution of discrimination complaints in employment, in housing, public accommodations, as well as hate violence.
Now that we have established that you are the expert, let's see what questions small business owners have for you. Let's turn on the question cam and see who's out there.
I've heard a lot about the ADA and FEHA. What's the difference?
Let's start with basics. The Americans with Disabilities Act, or the ADA, is a federal law signed by President George H.W. Bush in 1990, which is really a federal baseline of laws and regulations to ensure equality for those with a disability. FEHA, the Fair Employment and Housing Act, is a California law that covers more than the ADA.
Really? Because I hear so much about the ADA. What is so different about FEHA?
Well, individuals with disabilities protected by the FEHA are persons with a physical or mental disability or medical condition that limits a major life activity. These impairments might be a back or knee injury, poor vision or hearing, arthritis, carpal tunnel, memory loss, depression, or learning disability. On the other hand, the ADA requires that the disability must substantially limit a major life activity.
What is a major life activity?
A major life activity would include such things as walking, talking, seeing, hearing, speaking, caring for yourself, or working.
Well, does the ADA have different criteria in the major life activity of working?
Yes, the ADA considers an individual to have a disability when it substantially limits a major life activity or working, when that individual is significantly restricted in his or her ability to perform either a class of jobs or a broad range of jobs in various classes when compared to the average person. However, California's FEHA considers an individual to have a disability when it merely limits a major life activity or working when that individual is limited in performing the requirements of a single particular job that the person seeks, desires, or holds. When determining whether a person is limited in a major life activity, the FEHA disregards the beneficial effects of mitigating measures.
Interesting. What exactly are mitigating measures?
Mitigating measures are things such as aids, or services, methods, or devices that would alleviate the effects of a disability. For example, these include medications, hearing aids, assistive devices, canes, and wheelchairs. Under the FEHA, mitigating measures should not be considered in determining whether a condition limits a major life activity. This would be the same under the ADA Amendments Act, except for ordinary eyeglasses and contact lenses.
Wow, FEHA does cover more.
Not to mention that FEHA also protects individuals that are or have been discriminated against because of a history or record of impairment.
Can you give us some examples?
It could be discrimination based on a prior work injury, a prior history of alcoholism, or a person with cancer that's in remission. You know who else is protected by FEHA?
I don't know. What could possibly be left out? It sounds like you've mentioned everything already.
Well, FEHA also protects individuals whom the employer regards, perceives, or treats as if they have a disabling condition.
What does that mean exactly?
It's about an employer drawing a conclusion that an employee or an applicant has a disability or medical condition, whether or not that's the case. For example, if an employer has an employee who's obese, and the employer thinks that that person may have diabetes or high blood pressure or some kind of underlying heart condition that may affect job performance and then refuses to promote or even terminates the employee or applicant for this reason, this would be unlawful disability discrimination. So a perceived disability is also covered by the FEHA.
That's amazing. I'm trying to think of something that FEHA doesn't cover. Is there anything?
Actually, yes. The FEHA does not protect individuals with sexual behavior disorders, compulsive gambling, kleptomania, pyromania, or psychoactive substance use disorders resulting from the current unlawful use of controlled substances or other drugs. This would include people using prescribed medical marijuana.
Let's check in with the question cam. What's your question for Phyllis?
How long after the ADA was enacted did California implement the FEHA?
Excellent question. Phyllis?
That's a really good question because it is a common misperception. The FEHA disability provisions have been in effect since the early 1970s, more than a decade before the passage of the ADA. California's law was actually signed into law by Governor Pat Brown as the Fair Employment Practices Act back in 1959 and reorganized as the FEHA by Governor Jerry Brown in 1980.
So the California law was enacted earlier than ADA.
Correct.
All right. California leading the way again. But why two laws? Why didn't the federal government adopt California standards?
Well, the ADA was created as a minimum standard for all 50 states. California's laws have historically offered greater protection to employees and applicants than federal law. The best way to describe it is that the federal ADA is the floor and California's FEHA is the ceiling. Yet because most news coverage focuses on the ADA, many employees and employers are not aware that our state laws are broader in many aspects.
Looks like we have another question.
I'm a California business owner. Am I regulated by both ADA and FEHA?
The ADA applies to employers with 15 or more employees, while California's FEHA applies to employers with at least 5 or more employees, even if the employees work part-time. If the discrimination involves harassment against a person with a disability, the FEHA would apply to an employer with even just one employee. All state and local governmental agencies are covered under the FEHA, so it's very important for employers, even small business employers, to realize that harassment is actionable under the FEHA for even one employee.
So just to make sure I've got this right, as a California small business owner, which law should I follow and how do I ensure that I'm in compliance?
Employers in California should always follow the law that affords the employee the greatest protection. However, this would exclude religious organizations for most jobs and the federal government. They don't have to comply with the FEHA.
Another question. Go ahead.
In a nutshell, what does FEHA require of an employer?
When it comes to applicants and employees with disabilities, the FEHA generally requires 2 things of employers. First, employers are required to engage in a timely, good faith, interactive process with applicants or employees to discuss reasonable accommodation. Second, employers must provide reasonable accommodation for those applicants who, because of their disability, are having difficulty with the interview process, or reasonably accommodate employees who might need an accommodation in order to perform the essential functions of their jobs.
So what does an employer have to do if he or she receives a request for a reasonable accommodation?
An employer must enter into a good faith, interactive process to determine what changes can be made or what equipment can be purchased that would allow the applicant or employee to obtain or maintain employment. It's simply a discussion that takes place between the employer and the employee or applicant.
If a small business owner wanted to find more information about these laws, where would they look?
A great place to start would be my department's website, dfeh.ca.gov, as well as the federal government's website, ada.gov. In addition, the Department of Fair Employment and Housing also has YouTube, Facebook, Twitter, and LinkedIn accounts to get updates.
Can't I just Google ADA and FEHA?
Sure, but the best course of action for any employer would be to take a course on the basic provisions of the ADA and the FEHA. By training your managers and supervisors on their responsibilities and developing a policy for your company, you can be prepared and help prevent discrimination as well as lawsuits.
And no one wants that.
Exactly. Also, the DFEH offers webinars to the general public for a small fee and to all state and other governmental employees at no cost. You can sign up for these seminars on the DFEH website.
Well, Phyllis, it's been great having you here, and I think we all understand the law much better. Let's give Phyllis Chang a hearty round of applause.